Bonjour. Ijo Benese, Indigenous cause. Maingan, Nindo Dam. My colonial name is Marvin Manningpenny. I live here on the White Earth Reservation. Today I'd like to talk to you about the revised Constitution and bylaws of the Minnesota Chippewa Tribe. That is our existing rule of law. I'd also like to talk to you about the Constitution of the White Earth Nation. I think these are very important subjects that a lot of people are not aware of. And today we'd like to share some information with you to point out what's going on with all of this so-called reform that's been going on for the past several years. This tells us who the Minnesota Chippewa Tribe is, and it describes who makes up the Minnesota Chippewa Tribe. And it's White Earth, Leech Lake, Fond du Lac, Bois Forte or Nut Lake, Grand Portage, and the non-removable Mille Lacs Band. That is the tribe. It's important to understand that this is the federally recognized tribe. Now there's been some efforts to change all of this, and there is a way to change this Constitution. And that way is through the amendment process. And this is what the people have to use, or the governing bodies have to use, in order to make any changes. And it has been amended 4 times, 2 in 1972, and certainly 2 again in 2006. What we want to let people understand here is there's some things been going on that is not appropriate or the right way to do it. Some things have been going on that people are unaware of. I know there's been a lot of statements made about the positive efforts that have been done here on White Earth for constitutional reform. I don't see it that way. Reform basically means you change something for the better. Some people may think that what has went on here has been for the better. I believe we have to take a look at that. All of us as members of the Minnesota Chippewa Tribe. There have been things going on here people are not aware of. Our current chairperson from White Earth has made great efforts to break away from the tribe. And by that, I mean remove White Earth from the Minnesota Chippewa Tribe as a separate entity. And some people will say, oh, that's good. Others disagree with that. And I think it's up to all of us to make that determination. We have to participate in this. But we'd like to show you some things that share with you certainly constitutional violations. And by that I mean there's efforts being made to change the Constitution without going through the process of Article 12. One thing that should be mentioned here before we go any further is this letter here from Norman Duchamp, who is the current president of the Minnesota Chippewa Tribe. This letter reads, and this was addressed to one of our tribal members here who has been in opposition to what's going on because it's going to change a lot of things that people are totally unaware of. But a number of tribal members have inquired about the process by which the revised Constitution and bylaws may be amended. I am providing this synopsis so that the membership understands the present status of our governing document. The revised Constitution and bylaws of the Minnesota Chippewa Tribe has a specific mechanism for amendments. There must be an election for that purpose called by the Secretary of the Interior, and the Secretary has a duty to call an election when requested by 2/3 of the Tribal Executive Committee. The Constitution may also be revoked by an act of Congress, but there is no mechanism for Congress to impose an amendment on the tribe. There have been 4 amendments to the revised Constitution and bylaws, 2 in 1972 and 2 in 2006. Although there has been an ongoing discussion about different proposals to change the existing Constitution, the TEC has not requested a secretarial election on any proposed change. As a result, the entire revised Constitution and bylaws remains unchanged. That fact was made clear at the last quarterly TEC meeting when enrolled decisions involving all 6 bands were made in strict conformance to the membership requirement that have been in place for 50 years. And this letter was written on March 26, 2014. The reason why we're bringing this attention to you is that, or this to attention to the membership, is that White Earth has went ahead under the guidance or leadership of Irma Visner and others who have chosen not to follow the amendment process to change the Constitution. In doing that, they held a referendum that everybody is saying, oh, it's a wonderful thing, they've done this, and 80% of the people have voted to adopt this new Constitution of the White Earth Nation. They have changed the name. And what's important to view here or look at is that what has happened is this Constitution was voted upon by referendum, and I hear a lot from Irma Visner, who states that 80% of the people that voted in this election voted for it. Well, that's what's being said. It's questionable. And the reason why it's questionable because 3,492 people purportedly voted in this election, and 712 voted against. So they're really applauding the 80% figure, and that figure should be really looked at closely. There are over 17,000 members of voting age that are members of the White Earth Reservation. So we have to take a look. If we take a look at those numbers, then it is quite clear that 80% of the people who are members of White Earth of voting age did not participate or vote on this so-called referendum. And this referendum was done not in accordance to our Constitution, but was rather done under federal regulations, and also an amendment to the Indian Reorganization Act that was passed in 2006, and that is subsection 476H of the Indian Reorganization Act. It was an amendment to the Act, and it's important to realize that this amendment does in fact state that the tribes can develop their own governing documents in Section 1, but in Section 2 of that Act, it does not allow that to amend or revoke the current Constitution we're under, and that's the revised Constitution bylaws of the Minnesota Chippewa Tribe. It's very important to remember this. This still applies. But, so there have been things here, violations of the Constitution. The Tribal Executive Committee is to be the body who oversees our current existing Constitution to make sure it is followed or done in a manner that's in compliance with this document. It wasn't done in that manner. There have been things that have been done that are after the referendum on November 19th, 2013, when they said they passed it. What happened on December of 2013, December 11th, as a matter of fact, this document here, a resolution to amend the Constitution, was presented to the TEC and asked to be adopted. What White Earth did, in essence, was put the cart before the horse. This should have been done first, and then your referendum run, or the adoption of this amendment through the secretarial election process. But we'd like to share with you an effort to bring this before the Tribal Executive Committee and read you a call for a censorship of Chairman Visner, or Chairwoman, pardon me, that was presented to the Tribal Executive Committee for action to be dealt with. But I'll read the charges and let you make up your own mind. Constitutional reform crisis. Under Article 10, Section 2E, a refusal to comply with any provision of the Constitution and bylaws of the Minnesota Chippewa Tribe. We charge that Irma Visner has willfully and maliciously committed constitutional law violation of the Minnesota Chippewa Tribe Constitution, hereafter MCT. Her so-called constitutional reform efforts are in fact seditious acts which include the defamation of the MCT Constitution and reformation of the existing form of the MCT government by unlawful means. We request that she be censored by the Tribal Executive Committee for her unconstitutional actions. The following are substantive evidence that support our contentions. The revised Constitution and bylaws of the MCT is the rule of law and governing structure for the Minnesota Chippewa Tribe. That is White Earth, Bois Forte, Fond du Lac, Grand Portage, Leech Lake, and the non-removal Mille Lacs Band. The MCT Constitution, as it exists until changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all. In a letter to the Tribal Executive Committee members dated October 13, 2009, this is the actual letter, Exhibit 1 we call it, and this is a letter that Irma sent to the Tribal Executive Committee, and it's interesting. These things are available to you by me if you so desire to take a look at them, but they're on record. Irma Visner informs the TEC of White Earth's intent to request a secretarial election pursuant to 25 CFR Part 81 to break away from the MCT. She also asserts that White Earth has the right to adopt their own governing documents through procedures outside the current MCT Constitution by way of 25 USC subsection 476H1. The pretext, a fake reason or motive put forth to hide the real one, that's all pretext means, of White Earth's initiative on constitutional reform was done in direct violation of the MCT Constitution and by a total misreading of the federal law and regulation that were used to advance this concept. White Earth is not, I repeat, is not an independent, federally recognized tribe. The Minnesota Chippewa Tribe is the federally created and recognized tribe under the Indian Reorganization Act. Furthermore, a clear reading of 25 USC subsection 476H is very unmistakable in that this amendment to the IRA does not invalidate the MCT Constitution. The real question is, what rule of law was White Earth following in conducting their constitutional reform project? More importantly, did the TEC sanction the measures White Earth used in doing what they did? Also, did Irma Visner on November 19th, 2013, or thereafter, submit a constructive resignation from the MCT. Considerable defamation and ridicule of MCT government is contained in the above-mentioned letter from Irma Visner to TEC members. When Irma Visner was installed as a member of the Tribal Executive Committee, she took an oath to preserve, support, and protect the Constitution of the Minnesota Chippewa Tribe. That's contained in the TEC bylaws at Article 3, Section 1, which appear to have been done by her as an intentional dishonesty. This is evidenced by her actions and negative statements about the MCT Constitution and its governing structure. Her exact words on the subject were that a single MCT government no longer has functional relevance. Obviously, her mindset is that the MCT Constitution is just an obstruction which does not constrain her from doing whatever she wants without constitutional restraint. Is she not answerable to the MCT Constitution, its structure, or the constituent body of the MCT? Chairwoman Visner has violated the MCT Constitution at Article 2, Membership, Section 1C, by adopting a document that provides for lineal descent enrollment for White Earth. When was the MCT Constitution amended by way of Article 12 to allow for this? Did the TEC in fact discuss with White Earth the implementation of the new White Earth Nation Constitution? That's Exhibit 2. This is a letter that was produced to by White Earth to the TEC, suggesting that the TEC was helping or assisting her in implementing this new Constitution. Whether that's true or not raises questions here. They deny that they have been assisting her in implementing the new Constitution. This is not the first time that Irma Visner has attempted to determine membership for White Earth that was in direct violation of the MCT Constitution. On 24th of October 1997, when a lot of things were happening at White Earth, there was a governmental change, if you recall, with corruption on White Earth, and Eugene MacArthur and Irma Visner were part of an effort to take and change membership here, granting to non-members certain rights that would take an amendment to the Constitution. This was never done, but they went ahead and passed a resolution stating that this could be done. Irma Visner presented a draft resolution to the TEC at the special meeting held on December 11, 2013 to amend the MCT Constitution. That is this resolution. Very important. A lot of people don't know what they were attempting, or she was attempting to do by changing the Constitution. This should have been done prior to any vote. This should have been presented to the Tribal Executive Committee for adoption before they went ahead and had a vote on this here. And remember, Whitehead couldn't just do it alone. It had to be all 6 reservations. That didn't occur. But this resolution has not, at this date, been adopted by the Tribal Executive Committee. So there's questionable things that are going on in our government that a lot of people aren't aware of or participating in. This sole amendment, if accepted by the TEC, if it is set up for a secretarial election and adopted by the constituent body, and all I mean by that is all of us who are members of the Minnesota Chippewa Tribe of voting age, would nullify or do away with this document. In its entirety as it currently exists. And that's the only thing we have, people, and would strip all MCT members of the rights, privileges, and immunities of this document. It should be noted that this effort is an attempt to uphold and sanction the constitutional wrongdoing that Whitehead did in conducting its constitutional mischief. Whitehead put the cart before the horse and chose not to follow the MCT constitutional mechanisms and procedures to attain their goal of constitutional change. Whitehead's constitutional travesty must be stopped and rejected. And this is important to all MCT members. You have to look into this because this is going, Whitehead's the biggest reservation with the most population, and but it affects all 6 member reservations. Irma Visner persists in her advocacy of Whitehead being an independent tribe and embraces a separation from the Minnesota Chippewa Tribe. I don't know if many members are aware of that, but by resolution she's attempting to do this, and I showed you the resolution. I think it's important that all tribal members remember this. This travesty must be stopped and rejected, or people have to be more informed on this. Irma Visner, like I said, persists in her advocacy of Whitehead being an independent tribe and embraces, there again, a separation from the Minnesota Chippewa Tribe. She's talking about, she wants to get out from under a colonial government, and that this new constitution will assert our sovereignty, and but in reality it will not. What it'll do is just reorganize under the Indian Reorganization Act. That's important to know. People should really take a look at what's going on here at Whitehead. This is being done in spite of the MCT Constitution, federal laws, and federal regulations, which restrain the unconstitutional actions that Whitehead has embarked on. What is being portrayed here is that the MCT Constitution has no relevancy to MCT governance of the bands that comprise the Minnesota Chippewa Tribe, and that they, the bands, individually can do whatever they want with impunity, and they're doing it. They really are, without people looking at and what's going on here or knowing what's going on. Excuse me. What has changed the governing structure of the MCT Constitution, which now purports to have granted absolute powers to the RBCs without the people's consent. They call themselves tribal councils. This is not so. The governing document says they are reservation business committees. The people have not voted to change that or change the status of them becoming tribal councils. So that's a myth. What has changed the governing structure of the MCT Constitution, which now purports to have granted absolute powers to the RBCs without the people's consent? Has congressional action, for example, the Department of Defense Appropriations Act of 1991, codified at 25 U.S.C. 1301A in 2006, or the Self-Governance Act of 1994, that is Title V, Public Law 93-638, the Indian Reorganization Act Amendment, subsection 476H in 2004, etc. There's a lot of federal laws that have been passed and being used as if they amend our Constitution. But the question we're asking is, has these laws amended our Constitution for us without our consent? The MCT Constitution at Article 12 states that Congress may revoke the Constitution, but does not say anything about amending it. That's very important for people to understand. Only the constituent body, that is all of us who are members of the tribe, can do that. Only we can vote and change our Constitution. The whole people of the tribe can amend the Constitution. The revised Constitution and bylaws of the Minnesota Chippewa Tribe has never been revoked by all the people. If the rule of law is not enforced for the people, the members are not equal before the law or before the Constitution. And whoever's in power can be arbitrary and not subject to the law, for the laws will be subject to them. What courts or tribunals then will address arbitrary policy and power? And we call upon the Tribal Executive Committee as overseers of the revised Constitution and bylaws of the Minnesota Chippewa Tribe to execute their duties to preserve, support, and protect the Constitution of the Minnesota Chippewa Tribe. Per the above-mentioned charges, we request censure of Irma Visner for the constitutional infraction she has perpetrated against the MCT Constitution. And myself and Ray Belkert preferred these charges against Irma to the TEC, which have not acted on this measure, and they should have. But there are a lot of things going on in tribal government here as far as the Minnesota Chippewa Tribe is concerned, and people must really take a look at it. But everything I talked about here, after we presented to the CEC, like I said before, Norman Deschamps, in fact, sent this letter to Ray Belkert on March 26, 2014, and points out that the Constitution is still intact, it's still the rule of law, but Irma Visner has chosen to go outside, the rule of law and try to push this thing through, and we're all going to be affected by it. So hopefully we continue to bring you information and further inform you as to what's really going on at White Earth with this all this clamor about constitutional reform on a White Earth reservation. I thank you.